Hello, good morning. My name is Schuster, one of the partners here at MWL. Today we're going to be talking about tips for successful fire loss subrogation from loss to trial. The goal here is that this is the first in a series of webinars focused on primarily property subrogation. We've done a series on healthcare, health subro, and folks liked it and asked us about property. So today is going to be a bit of an overview. The goal is to talk about like from the moment a fire is reported to an insurer through trial. So obviously a ton of ground to cover in an hour, and so it's a bit of an overview class. But don't worry if there's something where you're like, well, he didn't say a lot about that, or he could have unpacked that. We'll have more focused webinars on a lot of topics that come up in property subro as we go on. And along those lines, if you have any requests or ideas about what you're seeing on your desk in property subro, feel free to pass them along, and perhaps that's something that we could talk to folks about at a different webinar. I gotta grab my glasses because I can't see my own screen. So if you don't know how to use a webinar, go to webinar. You and me both. Today it seems like we have a lot of different programs like Zoom and Teams and Uber, and now this is what our firm uses for webinars. I don't know a lot about how to use it, but I understand that you can ask questions, and if I see them or if our marketing monitor hands them to me or tells me that you have questions along the way, I'm certainly happy to answer them as we go if I'm able. So with that said, and without further ado, off we go. Okay. One of the main goals to talk to you about is that when a fire is reported to an insurance company, that should be immediately triggering bells for the company to think that subrogation maybe or likely is implicated. The reason being, fires almost never happen for good reasons, and therefore subrogation should be attended to from the jump. And what I say for no good reason is, of course, fires happen on accident, although they can be set intentionally, of course. But the vast majority of fires are accidental, but they happen because someone or something made a mistake. The difficulty for subrogation professionals is in finding out what the mistake was or mistakes were that caused the fire, and then improving it. So from the jump, be thinking about, if you hear about a fire and you're working in subrogation, or even a first party on the first party side, be thinking, if there's a fire, there's the potential here for subrogation. Some insurance companies, of course, divide subrogation out as a completely separate department from first party claims, while others, usually smaller mutual companies, the first party rep might also be the subrogation rep. There's pluses and minuses to doing it both ways. One of the things I like when the first party adjuster is a subro rep is that person can explain to me why a certain damage was paid, or they usually have a really good understanding of the file overall, whereas subro is coming into it later. But in any event, if you're in subro, talk to the first party folks and let them know, hey, if there's a fire, they should be trained up to know if there's a fire, bring in subro right away, because there's a likelihood that something went wrong, and you might have a chance on subrogation. This is the roadmap for the presentation today. As I said, we're here for an hour. I'll try to go more quickly, but I'm not sure if I can get through it in less than like 50 to 55 minutes. These are the topics that we're going to talk about, some in more depth than others, all the way from the fire to trial. And this is how I categorize all fire claims in my mind. First, there's the fire. It eventually gets to subro, statements and fact roundup, then site work. And usually the site work and evidence harvesting and preservation are done jointly. That's one effort, but I think about them separately in my mind. And usually the site work will involve at least 2 visits from your cause and origin investigator, and we'll talk about that, and potentially other experts, and 1 visit from folks on notice, they're experts. From there, there's lab examinations or artifact examinations, some folks call it. Whatever evidence is harvested and is potentially causal. If you're harvesting products, you need to look at them in a lab to determine if there's arcing, or if your experts can determine whether the product failed or what evidence shows about how the fire started. After lab exams, and sometimes there's one lab exam, sometimes there's several. I'll tell you as a general proposition, the more lab exams there are, generally the tougher my subro case is, because it means that our experts sometimes aren't sure. Sometimes it's just because there's a lot of things that need to get ruled out. Maybe it's a fire in a garage. The garage might have a panel. It's down south. The panel might be in the garage. It might have a fridge, like a beer fridge. If you're up here in Wisconsin, everybody's got a beer fridge in the garage. And might have a car, and it might have car batteries, boat batteries, a lot of things that need to get ruled out. So those types of fires can lead to multiple lab exams that don't necessarily mean you're having trouble on subrogation, but as a general proposition, the more lab exams I see, the more leery I get, like, oh, my experts might not know what happened here. So just something to bear in mind. After you determine the cause, then typically there's attempts at resolution, and if those fail, you're into the lawsuit. And lawsuits can end early, and oftentimes they do, and they can go all the way to trial, and we'll talk about each of those phases today. Excuse me while I grab my water. We'll talk about each of those phases today, but just quickly. So a fire claim occurs and lands on your desk. You're part of the subro team. What happens next? Of course, you need to take witness statements, starting with your insureds. The question here is, should the subrogation rep take the statement, or should a cause and origin investigator take the statement? Sometimes you need to take a statement before you even know if you should hire a cause and origin investigator. And sometimes before subrogation is even involved, the first party rep will have already taken statements. But I want you to think about what the first party rep's standard statement would include, and what the goals are there, and sort of what the questions on that person's outline would be versus what your questions would be in subrogation. And what you want to know as a subrogation professional, in my eyes, obviously you want to know what happened, were they home, all of those basic factual pieces of information. But the goal for me, if I'm taking this initial statement, is to find out, does the insured or any of the witnesses, can they pinpoint the origin area in their mind? Obviously they're not experts, but can they tell you what you're dealing with? Were they home and they saw smoke from the basement? Okay, really good clue. Were they home and they they noticed smoke coming out of the rafters in the attic, or in the ductwork, things like that? Those things can be good clues. And then depending on what they tell you in terms of facts, for example, a lot of fires that subrogation departments see these days are dehumidifier fires. These have been ongoing for like 10 years, and they're not going to get better. And I could talk to you for hours about dehumidifier cases. But if it's a situation like that, the insured might have even encountered the product on fire, or the fire department may have went in the basement and seen. We went down there, and literally the only thing on fire was the dehumidifier and just a ton of smoke. If that happened, where you have a situation where a product is potentially implicated, and you know that from the jump, you want to get your insureds habit and practice on purchases. Do they typically use a card? Could you get card ledgers from them if you needed to? Do they typically shop at Lowe's or Home Depot? What's their habit and routine with respect to purchases? And of course, if they know the product right away that's potentially implicated, when did they buy it? Where did they buy it? What make and model was it? Do they have the manual? Can they get you the receipt? All very important. Order fire department reports right away. You all know this. They might not be available, but ask your insured, hey, what fire department or fire departments showed up to the scene, and then go ahead and get those FOIA requests out so that when the reports are ready, they'll get them to you. Another advantage of ordering fire reports early is that if you have your request in before the report is done, sometimes that triggers a response from the fire department to make sure that their report is robust. Not always, but sometimes. And then finally, remember that in today's day and age, a lot of homeowners have cloud security systems, Ring, Blink, and there's 100 others now. And a lot of times the homeowner has not paid for the subscription to store the data, but the vendor still has that data. And if you jump on it early, you can get those videos. Even if you think the video, if you have the video, or it might not be useful, like, hey, it was a basement fire and there's only exterior video, get it anyway, because sometimes it's useful for an ancillary purpose, such as eliminating a weather event that you might not foresee on the front end, but later could become very important. You know, people claiming that there's lightning strikes and that caused a problem, and they try to derail your case, and maybe that video could help you in an area you didn't expect. So do what you can. It's legwork, and I know we'll talk about in a bit. Claim professionals these days, both on liability and in subro and on the first party side, have an intense caseload, often, or claim load. And I know you have a lot of things to do, but these are all things that can help you on the back end to achieve better subro results. So you've done that basic investigative work. The next is the first site visit. And the person who should attend your first site visit is whomever you've hired as a cause and origin investigator. Some insurance companies have these folks, these experts internally. Usually they come from fire departments and they're trained. You know, they've gotten fire investigation certifications. Some, like I said, some carriers have these folks in-house now, and a lot of carriers still don't, and they use, you know, NEFCO, SEA, ESI, EFI, pick your vendor. One thing I would mention about vendors is I would, as with law firms, I say this, I'll say this to anyone who will listen, as with law firms, choose your fire investigator, not your fire investigator company, because all of these companies, just like law firms, have excellent fire investigators, and then, you know, some that aren't as great. The goal of the first site visit, and remember, this is just your fire investigator, or maybe, you know, if the fire investigator goes out with a claim rep, that's fine too, but there's no potentially adverse parties at this visit, because usually you don't know who they are yet. So your goal at this visit is, one, document the scene in full, and we'll talk about that in just a bit. Two, get an idea from your cause and origin investigator about your chances for subrogation here. Sometimes a fire is so severe that your fire investigator will go out there and say, look, Rich, this is going to be extremely tough because there's nothing left of the scene. I had a house in a high wind event, and I kid you not, the house was gone. The only thing left of the house, there wasn't even any like framing. It was all gone, dust, like 98% dust. The only reason that we recovered on that particular claim is because there was no power to the house, and the only thing that was like an energy source was like a pot heater that the mason had put in the garage, and that it ended up being pretty clear that's what happened. But all that to say, the scene could be range from the house is in great shape and only the area where the fire started is charred and burned, or it could be there could be no scene left, or oftentimes what happens on big fires is the fire department goes out, and as part of the fire suppression efforts, they collapse the roof onto things, and you just need a sense from your expert of what things look like and how possible this is going to be. Another thing they can do on that front is they can tell you, okay, we're gonna have a joint inspection with whoever you need to put on notice, whoever the potential targets are, and at that inspection, are we going to need any labor? Are we going to need a skid steer? You know, are we going to need some equipment out there to help unpack the scene or not? Determine notice issues. your insured should be there or should be available to your expert, and your insured should talk about, was there any work done in this area of the home recent to the fire? Was there any products in that area? Hopefully your expert will be able to identify those products. The scene won't be so far gone that you can't. Was there extension cords? Where were they purchased? Get as much information from the insured as possible, and someone, either the subro rep or the first party rep or the expert, someone who has a good relationship or can have a good relationship with the insured, needs to help the insured understand that this is homework, and insureds don't like to do it, but it's very important. So whoever can have that conversation needs to have that conversation early. Like, hey, we know this is going to be some work, and you just went through a fire, and this is an awful experience. And we're going to help you through it, but we need you to help us too. We want to find out what happened here, and you should too. So we need your help. Then, at this site visit, your cause and origin investigator should document the scene in full, the entire exterior of the home and the interior, paying particular attention, of course, to the area of origin. And also at that initial inspection, your cause and origin investigator, alongside you, or if you have an attorney involved at the time, alongside your attorney, needs to make a decision about whether or not to harvest critical evidence right then and there. The general rule is if you harvest it, later defendants, folks you put on notice, are going to be upset. You ruined our ability to inspect the scene. However, if you document the scene very thoroughly, and we'll talk about that just on the next slide, then it's less of an issue. And also you have to weigh the risk of them being mad versus what happens if this evidence disappears. How critical is it? Sometimes, again, referencing dehumidifier cases, sometimes the fire department will go down into the basement where the dehumidifier is. They'll see it's on fire. And this happens a lot. They'll literally grab it and they'll toss it outside. If that evidence is already in the yard and not where it was at the start of the fire, there's no reason to leave it in the yard. And the harm to your subro case, if that dehumidifier walks off or disappears or gets cleaned up on accidents, things like that, thrown away, is catastrophic. And the harm of you collecting it is minimal. So you weigh that risk. And then your cause and origin investigator should leave that initial site visit with an understanding of what the joint inspection with all parties is going to look like. Okay, on documenting the scene, photos are good, but it's 2022 and we can do better. If the loss is of any size, then I recommend video. Sometimes companies don't like to take video because it's a storage issue. Their platforms don't allow storage of a certain size. I don't know how to work around that other than tell you video is really good, particularly for someone like me who might come in later after the scene has already been remediated. It allows me to see how the house is laid out better than just a floor plan could. If it's also available, get a Matterport. They're really cheap these days. I just looked them up in preparation for this webinar. A standard Matterport on a fire scene is about $300. It can range from the area of the country and the size of the property that's being Matterported, but it's $300. Also, a lot of carriers have Matterports these days. The Matterport camera is about $3,000, can go up to $5,000. A lot of companies have them already, or your or a vendor that your first party folks are using, like Paul Davis or whoever you're using, they should have a Matterport. So get someone to do a Matterport for you, because it can be really helpful later for 100 different reasons. But one of them is if you have to show a jury what this house looked like. It's a lot better than just showing photos, and it's cheap. Same with drones. They're pretty expensive these days to get a drone on site. And I recommend that you do drone footage when it has to be a significant loss, let's say 6 figures, because it'll cost you about $500 to get a drone footage. Can be cheaper, but approximately. If it's a potential attic fire or fireplace fire, I really think it's good to get drone footage because it shows you an aerial of the home. Another way you can do that, but it's less effective, is if you have a skid steer on site, you can raise it and have your cause and origin investigator during the joint inspection take photos from above. Usually a drone's more effective. Skid steer is very expensive, but you might need it to help remove debris from the scene. So another way to do it, if it's a potential attic, second floor of a home or fireplace type fire, get photos from top down. Those will be helpful to your engineers, to your cause and origin investigator, and your lawyers later. Photos before and after of a home, just to show you the story that you can tell and how different a site can look, and the importance of trying to gather information from your insureds as part of your investigation. Obviously, the photo on the left is pre-fire, so it was only through the good work of the claim handler that we had them, and they became critical because this house clearly is really nice. We wanted to establish why it was over $1 million loss. It helps to have these photos, like look at what was destroyed here, and all that it took, to rebuild this house because it was a total loss. Same thing in the origin area. This particular fire was a fireplace fire. See a lot of those. Usually it's an installation error. There's a clearance to combustible issue, meaning somebody put some piece of framing or some piece of building material too close to the fireplace. And this one, it was the back of the fireplace. And this is the room before the fire and after the fire. Obviously, the photo on the left is a lot earlier than the fire because the TV is quite old and they updated the TV you can see in after fire. But it gives you a sense of what it looks like if you get good photos of pre-fire. Now, before you go to a joint inspection, which will be the next landmark event in your investigation, you need to put parties on notice, of course. A few pointers on notice. Include what we call pass-on language. It's just a sentence or a paragraph at the end of your notice that says, hey, if you're aware of anybody else that is a potentially interested party in this fire, we ask you to A, forward on this notice, and B, contact us to let us know who they are so that we can include them on future communications. Really important in settings where it could be a construction issue where you're just putting the GC on notice because you might not know who installed the fireplace or the furnace or did the electrical or the panel. Also really important in product liability claims because you may know the retailer, you might know, hey, this product was purchased at Home Depot, but you don't know anything about who manufactured it, who Home Depot's vendor was, and those things can be important. We'll talk about a bit later because sometimes you can't even sue the retailer. That's particularly true in innocent seller. We call them innocent seller states. Some states now, this is going a little deep for the overview course, but some states now have statutes that say in a product liability action, you cannot sue a purely innocent seller, someone like Lowe's that just passes on the product in a sealed box. States that have those statutes, you need to get back to the manufacturer, but bear in mind that even in innocent seller states that don't allow you to pursue the retailer, there's often exceptions to those rules that would allow you to pursue someone like an entity like Walmart or Lowe's. More pointers, if you can, include photos of the loss. If it's a product issue, a product potential claim, include the receipt if you have it, the manual cover if you have it. And once you send out these notices, you're going to get back, I'm sure many of you have experienced this, you're going to get back a letter, standard form letter from all of these companies that give you a list of 20 things that they demand that you provide them right away. If you don't have what they're looking for, don't freak out, as I write here. It's not that big a deal. They should attend the joint inspection or not attend the joint inspection at their own peril. You're giving them what you have, and it's up to them to decide if they want to spend the money to come. If they argue later, hey, we didn't have enough information to identify the product, then tough luck, folks. That's why we invited you to the scene, so you could do just something like that. So don't worry too much about these standard letters. I actually get quite frustrated with them. because they're form documents, and what they're intended to do is they're intended to make you jump through a lot of hoops to make pursuing a claim difficult. They also have legitimate purposes in trying to get information, but a lot of the things on those standard form checklists that companies send are not necessarily necessary at this stage of the game. Also, over-include. If you're not sure if an entity should be on the notice, put them on the notice. And if they contact you and say, hey, what's this all about? Just explain. Just give them the straight dope. Tell them, look, we're not sure what we're dealing with yet, so we want to be over-inclusive. They can make the decision to come or not. That's up to them, but you're inviting them. Do you provide a protocol? Comes up a lot. Clients ask me about this a lot, even on claims that I'm not handling. They'll just call and say, hey, we've been asked for a protocol. What's your take? Generally speaking, on run-of-the-mill fires these days, a protocol is not provided for usual fires. People will say, well, NFPA says you should do a protocol. Whatever. I'm telling you, the standard practice is all experts know we're going to go out to the scene, we're going to unpack it, we're going to do it together, and it's going to be like a systematic effort. If someone requests a protocol, then I would provide them one, and your cause and origin expert should have a standard protocol that is pretty form and doesn't give a lot of information. It says essentially what I just told you. We're going to go out there, we're going to have a look, and everybody's going to play nice, and that's that. Some big companies like Toyota, for example, very notorious for demanding a very robust protocols. Then they'll object to the protocol. Can be frustrating, and if you run into that and you're feeling insecure about what to do, give your preferred lawyer a call, and they can give you a hand, even if they're not handling the matter. They should be able to help you out with that without too much trouble. Which experts do you send? Of course, you send your cause and origin expert. That's who's running the scene for you. Do you send an electrical engineer? Depends on the laws. But I would say this, as a general rule, one of my tips is I'm more likely to send an electrical engineer to the loss location for the joint inspection than I am to send my cause and origin investigator to the lab exam. Let me say that again. And if there's about 200 people here. So if there are cause and origin investigators here, as the kids say, don't at me. But I'll say it again. I'm more likely to send an electrical engineer with my cause and origin investigator to the joint scene exam than I am to have my cause and origin investigator attend the lab exam. It's not a hard and fast rule. It doesn't apply in every single instance. But as a general rule, I don't need a cause and origin investigator at a lab exam. You can save that money. Okay. Some considerations about whether to send an EE or not. Is it a scene that arc mapping may be necessary, and is arc mapping going to be possible? What's the size of the loss? As with everything, the size of the loss and the complexity is going to drive what you do. Show some photos of the scene to your preferred electrical engineer. Is this something that arc mapping is going to be needed, and is it even going to be possible? And deal with it that way. Do you need to send other trades out? Generally not, maybe mechanical, but usually the two that would attend a joint scene on normal average, we'll say fire losses would be of course your cause and origin investigator and potentially your EE. Also important, at a joint inspection, is your insured going to be there? If your insured is going to be there, if you have counsel, your counsel likely needs to give your insured a heads up, or at least find out what that insured is going to say. When you go to a joint inspection, whoever attends, they huddle up at the beginning. Everybody signs in, puts a card on the table. There's usually a glue stick. They glue their card to a little sign-in form, and then your cause and origin gives a synopsis of what he or she knows at that time. We think that, the ordinary appears to be over here. We're going to start with all of you taking your, what they call them, overview shots. Everybody do your overview shots. Take 45 minutes, come back, we'll huddle up, and then we'll decide where we're going to go from there. It's like that type of event. At that time, when everybody's huddled up, if you're insured there, the other folks on that are experts for other parties, they're going to want to ask your insured's questions. And there's a provision in NFPA 921 that says essentially they should be there and they should be available for questions. My standard approach, because you never know what an insured is going to say and they can get quite talkative, is as follows. If you have questions for our insureds, give them to our cause and origin investigator and we'll get you answers. Sometimes you'll get pushback on that, but I'm pretty firm about it. I've literally had entire subrogation efforts either scuttled or made much, much more difficult by mistakes, factual mistakes, and just sort of word salad given by insureds at joint inspections. And then 4 months later, they've already said it, everybody there's heard it, and they say, no, that's not what I meant this, that, or the other. It's tough to unring that bell and convince the parties that were on site, like, no, this actually is your fault, they just made a mistake. So I'm very careful about what I allow insureds to say if I'm involved in a case, in a claim at that point, and you should keep that in mind. Again, my recommendation, others disagree. I know NFPA 921 has some thoughts on it. Have people who attend, let them know to get you, to get their questions to your cause and origin investigator, and he'll get answers for them from the insureds. I even prefer if my insured's not really on site. That's just me. Okay, so everybody takes overview photos. One pointer here, encourage anybody on site to take damages photos too. Because if it's a product liability matter, or strike that. If it's a matter where you're later pursuing several, the other side might say, well, we don't have any evidence of, that these contents were in good condition, that the house was ever updated. And what you want to be able to tell them there, in addition to being able to provide them photos or video, is, hey, you were at the site inspection. You should have taken those photos. It's your fault that you didn't. So I encourage whoever's there for any potentially adverse parties to take all of the photos, video that they need, including damages photos. Your experts at the site, they will be focused on a particular area of origin, and that area of origin will have some electrical devices or things that they think are potentially causal, and they will make a collective, usually group effort decision about what to harvest. If there's a disagreement about what to harvest, over harvest. Sometimes it can be a pain. Someone will say, well, I want the automobile that was stored on the other side of the garage to where the clear area of origin was. I want that harvested. And you don't want to pay vehicle storage costs. I usually try to strike a deal like, we'll harvest it, but you pay for storage. Usually, the people on site for the adverse party don't have the authority to do that, and the folks who do have authority won't agree. I still usually harvest, and I tell them, you have 30 days to do what you want to do with this car. Sometimes, if you're on for the homeowner's insurance carrier, for example, that's usually who's leading the subro effort. The automotive carrier, you could work with them and they'd pay for the storage. So it's something to keep in mind. What to harvest? If you're dealing with products, here's my recommendation. Harvest the product all the way back to the outlet and take the outlet as well. So using dehumidifiers as an example, oftentimes the dehumidifier will be plugged into either a power strip or an extension cord. And then that's plugged into the outlet. Take the dehumidifier, take the cord, take the outlet. Okay, that's my recommendation on any product. It's not the end of the world if your expert doesn't take the outlet. It just looks more thorough, and it is more thorough. Next issue is when to arc map and what is arc mapping. That's a lot for this overview class, but generally follow the opinion of your cause and origin investigator and your electrical engineer about whether to arc map. Arc mapping traces from the origin of the fire back to a source to try to help. It traces from the area of arcing back to an area of origin to try to pinpoint the area of origin of a fire if that's something that is potentially disputed. Sometimes the area of origin is so clear. I should have put some photos in that shows like the clear V patterns in a certain area, and on either side of that particular area, everything's fine. In situations like that, generally don't need arc mapping, but sometimes it's a lot more complex and arc mapping can be helpful. I threw this photo in here because it's an example of, you know, when you get to a joint inspection, there's sometimes some very big clues about, hey, what might have went wrong here. Obviously, this is a huge heater that's got some OSB directly in contact with it, heating this building. Terrible idea, but you see a lot of things like this when fires are involved, or when you have fire claims. Okay, you've gotten through the inspection. After the inspection, you as the subro person, make it a habit of getting everything from the inspection right away. Get your experts' photos and video right away. Get the chain of custody form for whatever was harvested and where it's going to be stored right away. Same with the sign-in sheets, because people like me are going to need those later, and it's just difficult to be chasing that down. The more you have organized when you refer it out, if you need to refer it out, the better. Then schedule the artifact lab exam. That's a little like herding cats, and it can be frustrating because folks' schedules won't line up. If you have run into scheduling problems because there's a lot of, it's like a multi-party situation, here's my advice. Give them a ton of notice, 4 weeks, 6 weeks, set the date. And usually I'll make sure, like, if you have like a particular target, like, okay, we think it's this party's fault, but there's a lot of ancillary parties, but we think it's this party's fault, make sure that they're good with the date, and then give the rest of the ancillary parties a month and let them know, look, we're going forward in a month. You have a month's notice or 6 weeks notice. That's plenty of time to get someone out there to attend the lab if you want. And that's only if it's too difficult to, like I say, herd these cats to attend the lab. At the lab exam, you're going to run into some of the same issues that you run into at the joint inspection. But here at the lab exam, your typically your electrical engineer or your mechanical engineer, depending on the type of fire, is going to be leading the show. Do you need a protocol? Sometimes. Follow your expert's lead. If, generally speaking, protocols aren't needed these days, but on serious fires, write one. If there's multiple parties attending the lab and someone requests one, give them one. And your experts can author those for you, and it shouldn't be expensive. They have like form protocols that they can use. Okay, should your CNO or your attorney attend? As I said previously, and my great fire investigator colleagues and friends, don't be upset. Generally, I don't think a cause and origin investigator is needed at a lab. Often what you hear from a cause and origin investigator is they want to be there for continuity. I'd rather save the money on a run-of-the-mill fire claim. If it's very serious, fine. If it could become an issue, fine. But usually I don't have my cause and origin investigator attend the lab exam, but I'm also cheap. So, you know, others might disagree. Do you have your attorney? This is a good point. Do you have your attorney attend the joint inspection or the lab exam or both? It depends on the case. You know, a lot of times you won't even have attorneys involved at this point. If I'm involved, if it's a serious matter and it's the travel to the location isn't cost prohibitive, I'm going to go. Not because I'm going to be any use at the joint inspection. I'm just going to be in the way. But what I want is to be able to see it, and as they uncover something that's important, talk to my experts about, like, hey, why is that important? What's this about? It's immensely helpful to be there up front later on. And it's an advantage if the folks that you're targeting don't have if their people have never been on site. Same at the lab exam. Sometimes they can show you what they're doing in a way that makes sense to non-technical people. It's helpful for me because I'm, generally speaking, not that bright. So for them to point at something and say, do you see this? Yeah, I see that. Instead of looking at a photo, this is what's going on here. That's helpful to me. Although there's many, many, many times where I'm not at the joint inspection or the lab exam, either because, you know, the claim's not located near my office and my practice is more national because I focus only on product liability and fire cases. Either that's the reason, it's just cost prohibitive and the size of the loss doesn't justify it, or it's not a real complex matter. Or these things have been done before I've been hired. So either is fine, is really the bottom line there. Finally, a tip: don't get written reports from your experts at this stage of things. You can. It's not the end of the world if you do, but it increases costs for one, and also your experts are going to be locked into those reports. They may be locked into those reports, especially if you're in state court. In state courts, and a lot of state courts, draft expert reports are discoverable. In federal court, they're not, but in a lot of states, they are. So I almost always recommend clients do not get written reports from any experts until they are due to the adverse parties on the deadline set by the court, which is almost at the end of litigation. Attorneys will ask you before they accept sub on a case, hey, send me the reports. Just explain to them, I don't have the reports, but here's my expert's numbers. And I think that that's fair. Also, adverse parties might not pay you without the reports. Okay, if it's a crystal clear case, maybe then you get reports. You have to feel it out. But generally speaking, if you provide a written report to an adverse party, all it does is gives them a year or a 2-year head start to aim at that report. And I don't like to do that. So I generally will say, look, I'm not giving you a report. This is what happened. This is what they'll testify to, but I'm not producing reports. And almost always, if there's an attorney on the other side, they understand exactly why. While you're doing these investigative things, I wanted to point out that the first party claim is proceeding. So some tips on that front. If someone, it depends on the type of insurance company you're at. Do they farm out the first party work? Is the first party person also handling subro? Is it a separate department? If you can, even if it's an RCV policy, and even at some policies now, a lot of policies, they pay ACV up front. Then if you replace the contents or you get the thing fixed, you'll get the withheld depreciation. But some policies now, they pay the RCV right up front. You don't have to, there's no recovered depreciation. They just give you the full RCV right away. Even in those instances, it's really helpful if your adjuster writes an estimate that includes depreciation in Xactimate or whatever program you use. Line by line depreciation is best, or item by item. And then do as much as you can in the file, or encourage your colleagues to do as much as they can in the file to properly document how depreciation figures were derived. Because you're going to see when you try to pursue your claim, they're going to fight you on damages. They're going to say you didn't depreciate properly. They're going to say you should have depreciated more. The more you have on that, the better. And if you don't have anything, then it's tough. If they just paid RCV and they never did an estimate that included depreciation, then you're looking at photos, you're looking at video, you're trying to go back in time and recreate an estimate, because in most states, you can only recover, in many states, in many circumstances, you can only recover ACV, not RCV. On that front, the measure of damages in the jury instructions in most states does not say actual cash value or replacement cost value. It uses the words fair market value and diminution in value. However, there's case law in many states that says fair market value is essentially the same thing as actual cash value. So even if you have a meritorious claim on liability, and many of you know this, but bear in mind there's 200 people here, and we have folks from all experience levels. Even if you have a great liability case, you're going to get pushback from the adverse on what's the right amount that they have to pay, and they're going to have a pretty good argument in most circumstances that they only owe you the actual cash value, not the replacement cost value. So you need to have an estimate that includes depreciation. Finally, code upgrades. In most states, you are entitled to receive whatever you had to pay as a carrier as a result of a fire in terms of code upgrades. You can't do the work without bringing the property up to code. Most states allow you to recover that. So you try to resolve the case. Just some quick pointers on resolving. Package your damages in a way that makes it easy for the other side. So what I usually do is I include an Excel or a Word table that has a payment, and with that payment, it's a specific amount, and I include an exhibit, which is it's an invoice from a vendor, or it's an estimate that shows exactly why that item was paid all the way down. And on a lot of claims, we'll produce to the other side, like, here's 35 payments, and here's exhibits 1 through 35 that documents every single one of these payments and why it was paid. It's both the proof that it was paid and the support for why it was paid. If you do that, it speeds things up on the adverse end. So they, because if you just produce them a mountain of documents, it's going to take them a long time to wade through. How long do you wait for a response? The general rule is if they're communicative and there's no statute of repose issues or notice requirements, governmental notice requirements or warranty notice requirements, then I'll work with them. If they're not responsive and you're not making progress, then I usually recommend clients file suit. Like, look, we're not getting anywhere. Don't wait any longer. Let's just file. I would note that many carriers have extremely overloaded claims professionals. I talked to just last week a very, very large international carrier who the claims professional, liability claims professional, told me he has 460 files right now. And that's unworkable. So he's almost apologetic, like I'm really sorry that this isn't faster, but this is what I'm dealing with on my end. So anyway, planning for litigation, the costs. Know what the costs are. Filing fees are about $500 in most states to file. Service of process, it really depends on what type of entity you're serving. Ask your lawyers, how much is it going to cost me to serve these entities? If they're foreign entities and you have to serve in another country, the costs can be significant. To translate a complaint and to serve in China, if the complaint isn't too long, is about $3,000. And whether you actually achieve that service is right now in China particularly, it's sketchy. We're getting a lot of service unreturned from China. So here's my strategy for litigation. Before I file a suit, I have my experts lined up. I have my first set of discovery requests in the works or done. My claim file, I have the full claim file from my client, and I have it completely redacted for what we're going to produce and a privilege log made. Then at the scheduling conference, I push for trial as quickly as feasible. And then the next stage is discovery, and I force full and fair discovery, and I become trial ready as quickly as possible. And using this strategy, I've given seminars on this strategy entirely. Using this strategy, you will win most of your subrogation cases. Let's unpack it just a bit. Who should I sue? These issues aren't always as easy as you think. Who should I sue and where should I sue them? You have to be cognizant of distributor statutes. If you don't know what that is, we're going to be having a seminar on that issue in a month or two. Jurisdiction, where can I sue them and are they subject to jurisdiction? Am I going to sue a company and it's going to be a waste of time because they're going to get out anyway because there's no personal jurisdiction over them? Where's it more expensive to sue? Consider that before you file and make sure your attorneys do. Also, same thing, where should I file? Should I file in state court or federal court? General rule, also very general. If you have a good case, I like federal court. The rules are stricter. The judges are generally more no nonsense. They don't allow as much in the way of game playing. Generally, not always. And if I have a good case where my experts are going to hold up no problem and I feel confident in the case, I like federal court. Sometimes you may prefer a state court because the venue in the county is better than the broader federal district, or there's 100 other reasons why you might prefer state court. Maybe you're very familiar or your attorney's very familiar with the state court and the adverse party is using attorneys, from far away and they're not sure about any local rules. There's a lot of things to consider, but they should be considered is the point. The scheduling conference is the first thing that happens after you file a lawsuit and they answer the lawsuit. The adverse parties answer the lawsuit. Most attorneys view it as like a non-event. A lot of attorneys even send younger associates to go to these scheduling conferences, even though nowadays most of them are by phone or Zoom. I don't feel the same way. This is my chance to begin implementing my strategy of making my strategy is generally I'm going to be very, very ready, and I'm going to be ready to try this case very quickly, and I want the other side who isn't as ready to be working from behind. So I try to set tight deadlines at the scheduling conference And if I have, that can vary if I'm like on a speculative case or I'm not real sure of the case, but I had to file because of a statute of limitations or for whatever reason the client was really pressuring me, and you know, I'm like, okay, I'm going to do the client a favor here. I might lose, but I'm going to try. Maybe set looser deadlines in those circumstances, but don't take the scheduling conference for granted as like a non-event. Discovery. This is the most important thing to me in a case, and in 10 minutes, I'm not going to be able to tell you all the reasons why, but we'll give this presentation again on why discovery is where you, as a subro professional and your attorneys as subro attorneys, this is where you're going to win or lose your cases. And winning and losing usually doesn't mean 0 or 100%. It usually means the difference between 50% and 80% on a subrogation claim. This is where you win. Here's a tip for you, and I've said this to anyone who will listen, and if you've heard it, I'm sorry, I just believe it with every ounce of my being. In discovery is where you will know, if you know what to look for, whether or not you have a good lawyer working for you or not. Whether or not you have like a plus lawyer or a minus lawyer. Is this lawyer better than the other side or not as good? The reason is because the other side is going to make discovery tough, and you're entitled. I'm thinking mostly of product liability cases now, which is a lot of fires end up becoming, or even like installation type cases. But you're entitled to whatever the other side knows and whatever might be helpful to your case. But the other side doesn't want to give it to you. I like this quote from Judge Parker. He was a Fourth Circuit Court of Appeals judge a long time ago. He said, "Litigation is not a children's game, but a serious effort on the part of adult human beings to administer justice." That's what we're doing here. And if you have like someone who's really a part of the profession and not just churning files and not just like a volume attorney, but someone who's really serious about their job, that's really what we're doing. We're administering justice. So it's, in my opinion, it's a big deal. Problem is they're not going to play nice with you. I won't read this quote, but Elizabeth Cabraser is a mass tort plaintiff attorney, and she talks about how incredibly difficult big companies, particularly manufacturers, are going to make discovery. And she says it would amuse Lewis Carroll. I had to look that up. Lewis Carroll, I'm not bright. Lewis Carroll wrote Through the Looking Glass and Alice in Wonderland. Her point being, discovery is like bedrock American, as I put on this slide. It's one of the things that makes America, it's a hallmark of American exceptionalism is a good way to say it. Most countries do not allow you to force the other side to be an open book. Hey, do you have a problem with this product? You can't hide it from us. That's the American system. Most countries don't have that system. But what her point is that they make it very hard for you to get the full and fair discovery that you're entitled to. Here's some tips. Keep this slide. Please take a photo of this. I mean this. I probably know more about product liability litigation than whomever you're using, and I don't say that to be arrogant. I've just been doing it for a long time. I lived in Asia for a long time. I handle cases for manufacturers and against manufacturers. That and handling fires is really all I do. I know a lot about this, and I know how companies in Asia work. This is all information you can get in discovery from companies, manufacturers, that will help you win a case. But your attorneys have to know what this is and how to ask for it and what to look for. So take a picture of this and make sure your attorneys are doing this. They're not going to want to give it to you. I can almost promise you that, but they have to. That's the law. When they don't, you will file a motion to compel. And when they don't adhere to the motion to compel, and many, many companies won't, and first and foremost, Asian companies, they're really bad at discovery as a general rule, you're going to get sanctions. These are just some samples of the sanctions awards we've gotten in the last, I'd say 2 years, I don't know, something like that. I get a lot of them. We've recovered well into 6 figures just in sanctions for companies that we're pursuing in subrogation claims that do not play fairly in discovery. And depends on your fee agreement, but oftentimes if you're on contingency, this money goes to you, the client. So there's been a number of instances where clients have called me, this is just a quick sick brag, where the recovery is over the payment that they made because of the sanctions, and their system doesn't really know how to handle that, like that we've recovered more money than they paid out. But it's a function of companies not playing by the rules, and you're not making them play by the rules in order to get them sanctioned. You're making them play by the rules because if they produce the documentation, data, and information that you're entitled to, their lawyers will know they're likely to lose the case because you're entitled to other incident data. Are they aware that this product is causing problems? You're entitled to design drawings, every version of the manual that they've ever printed. Did they change some stuff in the manual because it was unclear, it was no good, or they realized later that there was some foreseeable misuses of the product? For all reliability testing and UL testing, you're entitled to all of it. Anyway, just some examples. First motion for sanctions, second motion for sanctions is on the same case. This is a different case. This is a federal court talking about the defendants, a very, very large company, manufacturer. We moved to compel documents from them, and the court, in a written order that will live on forever in the federal record, saying that the defendants made some of the most stunningly meritless arguments the court has seen in over a decade on the bench. In that same case, well, they were ordered to produce complete and equivocal discovery responses. All of their objections to the discovery were stricken, so they couldn't object. They had to produce everything, and ultimately they did not. And what the court did in that case was conclude, because of their discovery failures, the court granted default judgment against every one of the defendants on the claim. In English, that means we won the claim without trial. We won it as a matter of law because they refused to play by the rules. Your lawyers must force adverse parties to engage properly in discovery and not let them off the hook. If they're not, you have the wrong lawyers. I mean that sincerely. After written discovery comes depositions. 30B6 depositions are depositions of corporate representatives. They don't want to give these depositions, and the testimony is binding on a company. Remember, it works both ways. They can take a deposition of the insurance company. So if you're an attorney, make sure that your client is very well prepared because the questions are binding on the company. Make sure that the notice of deposition isn't overly broad, things like that. Finally, on depositions, should you take them by a Zoom or in person? Generally today, I've already told you I'm cheap. I don't see any reason why almost all depositions can't be via Zoom. Two exceptions are, do you really need to evaluate the witness in person, and would that help? And two, if it's a document intensive deposition, it can be clumsy to do that on Zoom. You can share screens, but it can be clumsy. Depositions and deponents in China. If you're trying to depose a Chinese company, they're going to tell you that the Chinese company can't be deposed in China because of Chinese law. That is true. However, they can travel to Macau, Taiwan, or Hong Kong, all easily reachable from China, and courts regularly force them to do that. So it's not a way, it shouldn't be a way that they can prevent a deposition, though they certainly try. Make sure your attorneys know that. We next go to expert discovery. I've covered this before, but I rarely produce expert reports until this time in the case. And when you get to expert discovery, you're very close to trial. One thing to know about expert discovery is if you get this far in the lawsuit, even if you're on contingency, your costs are going to increase substantially because experts are expensive. They have to prepare for depositions, they have to prepare reports, and that can get costly. If your experts or the adverse experts are no good, that will compel what's called the Daubert challenge. If most of you are familiar, if you're not, that's the case that focuses on when an expert can testify at trial and when they can't. If the methodology used by your expert is unreliable, then they're not, as a matter of law, entitled to testify at trial. They're hard motions to win, but know that as a subrogation professional, you're the plaintiff. And if you lose your expert to a Daubert challenge before trial, you likely will lose the case without a trial. You cannot get to trial on a product liability case, and many times on an installation type case, if you don't have an expert to opine. Finally, trial. They're rare, sadly, but why? Cost is number one. Two, court pressure. The court puts a lot of pressure on parties to settle, forcing mediation and then settlement conferences with the court. A lot of times now they'll force the parties to appear at those settlement conferences in person, and all of these things are designed to force parties to settle. Attorney work, if you're on contingency, you shouldn't really have to worry about how much the attorney has to work, but I will say trials increase the work on a case exponentially, and in turn, it will make attorneys put a lot of pressure on you to try to settle the case. And then finally, people. People, I like to say people, especially comfortable people, are not used to and they don't like to compete. It can be a good or a bad for you if you're very comfortable in your position, and losing a case would, be bad for business on your end. I get it. And I would say that the same is true for the other side, and the same is true for the other side's attorneys. I just had a trial 2 weeks ago. It was clear that everyone in that courtroom besides the judge and I was very uncomfortable being there, and didn't like the experience and wasn't very good at it. So I think that's one of the main drivers right now. People just aren't used to putting themselves out there anymore. So in any event, the last thing I'll say is representing a carrier at trial. If you can sue in the insurance name, go ahead and do it, no problem. And then confront the possible prejudice in voir dire. That's when you get to talk to the jury before you pick a jury. You ask them straight out, has anyone ever made a claim to an insurance company? And then start your theme, one of your themes of the case, right there in voir dire before the case even started. You ask the jury by a show of hands, anyone here ever have the experience that an insurance company was just itching to pay you too much money? Because one of the things that they're going to say at trial is that you overpaid. You don't want jurors that agree with that proposition, and I'll give you a hint. Almost no jurors agree with that. Most jurors are going to say, no, insurance companies are not trying to pay you more than they owe. With that, if you have any questions, sorry I went 2 minutes over, that's just my nature. If you have any questions, you can put them in. I don't know how to see them, but Jamie Breen, our marketing, one of our marketing people, will help me to see them. If you put your email in there, I certainly will send you an email back. If you have questions that you don't know how to use the platform or would prefer to just email me or call me, I've put my email on this slide, my office number, and my cell phone number. I would just note you could call me anytime, particularly in today's world. I travel a lot, that's fine. Just note I have a 3-year-old. Try not to call me after 8:30 Central at night because I'm trying to get her to bed. It's like wrestling a chimpanzee most nights. So yeah, if you could call me before 8:30, I'd be grateful. Otherwise, feel free to call me at any time on anything. We'll help free of charge if we can, and we'll let you know before we charge you that, hey, this isn't something that we could do for free. I really appreciate your time and indulging me on a topic that I care a lot about. We'll go forward, say in a month, with another more tailored presentation unpacking some of what we talked about today. I appreciate your time, and with that, we'll end the webinar. I don't know how to stop this.